Hello, everybody. I'm Katherine Vesely. I'm an attorney at O'Brien, Brown & Toner. We have offices in Indianapolis and also in Louisville, Kentucky. I live in Louisville. I'm licensed in Kentucky and Indiana. I've been representing Harrison County Hospital in multiple different capacities for many years, working with Lisa Lieber. So if you have questions about who I am, please ask me. Otherwise, I'm just going to jump right in because this is all about you all. I had an interesting time kind of researching HIPAA for you all, for EMS providers. And so I wanted to give you, it's a little bit different depending on your perspective. And your perspective is from emergency services. So ask me questions. I'm going to start by just telling you a little bit of a story. And then I'm going to, and please jump in with participation, ask questions. Audience participation is good. So on December 30th of 2019, the Department of Health and Human Services announced that a small Georgia ambulance service agreed to pay a certain amount of money and adopt a demanding corrective action plan to settle potential HIPAA violations. Can any of you guess what the violation was?
Was it a 911 call and they went to another one? Is that what it was?
No. Good guess, but no.
Okay.
This was, I'll tell you, it was a laptop.
Oh,
They left their laptop somewhere and somebody else found it.
There was a laptop that fell off the back bumper of the ambulance. It was unencrypted, and it contained data that affected how many patients? You want to guess?
Multiples, thousands.
That's a good guess. This was 500 patients. So small Georgia ambulance service has this event. They reported it because they have to. And in doing that, they had to pay a fine. Anyone want to guess what the fine was?
A lot.
More than all of them.
$10,000 per incident, isn't it?
So this was $65,000 that they had to pay for this breach.
Per one, each one?
This was total. This is basically, I'm sure they were going to have to be fined like a lot more money than that, and they reached a settlement. So they said, we'll agree to pay $65,000, and we're also going to do this massive corrective action plan where we talk about HIPAA and all that kind of stuff. So hopefully that never happens to you all, but it was in 2019 to a small Georgia ambulance company. So I wanted to let you all know that this is real. And the stuff matters. Before you leave tonight, I'll give you a handout. Looks like this, front and back, with some tips. And then another one that looks like this. There are some good stuff in it, but I'm not going to give it to you now so you don't read. But we're going to be going over all of it. So hopefully when I give you the handout at the end, it'll be a refresher of what we've talked about here tonight. So for those who don't know, what is HIPAA? And it's 2 A's. Health Insurance Portability and Accountability Act of 1996. So that's a long time ago these days, right? So it's been around a while, and we're even now figuring out how it works, all the nuances of it. What does it require? Confidentiality of protected health information. It's also like any government thing is going to have a ton of abbreviations. So if I start spitting out letters, check me and say, what does that mean? So protected health information, and here's what it is for. It allows patients to access their own medical records, to correct errors or omissions in those medical records, it be informed about how their personal information is being used and shared with others, and be informed about what the privacy procedures are for the facility that houses their records. So this slide's going to tell you a little bit about what the health information is covered. So what is protected health information? So it's electronic records, it's paper records, it's fax documents, and it's oral communication, verbal communication. There are 18 different identifiers that are and these are important because, and I don't expect you to remember them all, one of the handouts has them, but they're just kind of reminders of what protected health information is, the different types of things that would be specific to an individual. So, name, address, date of birth, telephone number, fax number, email, all of that, social security number, account numbers, license numbers, those are all numbers that can go back to a person. Medical record number, health plan beneficiary number, device identifiers and serial numbers, like if you have a pacemaker, thank you. Vehicle identifiers and serial numbers, finger voice prints, full face photos, and then down at the bottom, other unique identifying characteristics of that person, tattoos and such. So anything that's going to, if you were overheard talking to a colleague about a person, even if you're not using their name, but you're talking about, you know, this patient had a giant eagle on his forearm or something like that, somebody may know who that is. So when does it apply? If you work or you volunteer for a covered entity. Covered entity CE, that's going to be a hospital, HCH, EMS services. It applies when you're on duty and when you're off duty. You can only share protected health information that you learn while providing services when HIPAA says that you can. We're going to talk about those rules. But the key is when you're treating a patient, when you're talking about treating a patient, when you're talking about the patient paying for those medical services, and when you're talking about operations. A lot of that is trainings or looking at how you can do something. If you want to do a case scenario about something that happened when you were on scene, you'll be able to talk about that situation without identifying the patient. That's all permissible. So the key for you all is, am I sharing this protected health information for a legitimate job-related purpose? If the answer to that is yes, proceed. If the answer to that is no, stop and don't go any further. Okay, so this is the key standard for all of HIPAA. You want to be, it requires that all authorized users only access the minimum necessary to complete a permitted task. We're going to jump into this, but you're going to hear me go back to this minimum necessary a lot. So the purpose is that it's going to limit the unnecessary sharing of protected health information. It does not apply to the treatment of patients. So when you're treating a patient, you and the patient can share as much information as possible. That's going to help you do your job in treating the patient. But this is the key rule. So when I said before, there's one question to ask, is it, am I doing this for a job-related purpose? If the answer is yes, then the next step is I want to give the minimum information necessary to get the task done. Okay, here's some easy rules. Don't tell anybody what you may overhear about a patient. Don't discuss a patient in the public areas, elevators, hallways, cafeterias. Don't leave patient information unsecured in print, piece of paper laying on table, or electronically. And don't look up information about friends or relatives unless you need the information to perform what your work is, what your task is. So when a breach happens, you're going to have to report it. And this includes things like a suspected or known or improper disclosure of PHI. So if somebody did find a patient care report sitting on the table, you're going to have to take that to your supervisor. Any lost or stolen device, like the example that I read at the top. Any malware, security threat, if you get an email and it says click here, and then that's going to get into your EMR system. Any known or suspected unauthorized access to PHI. Johnny goes searching for his mom's medical records and you know about it, that's a potential breach there. So the key here is to report the suspected breaches to your supervisor, and then your supervisor is going to guide you for the next steps. But there are compliance officers and there's a privacy officer who's going to take the next steps if the next steps need to be taken. Those aren't calls that you need to make. All you need to remember is, do I suspect that there's a breach? If so, tell your supervisor. So yes, as I said in the top, that $65,000 and the huge corrective action plan to kind of teach everyone what this was about and why it was so important. That's what happened to the Georgia Ambulance Company. There can be some serious penalties for these kind of breaches. Hefty fines, $1.5 million per violation, depending on the egregiousness and the gravity of the situation. Some can result in criminal charges, and then just failure to maintain patient confidentiality is also a violation of hospital policy and can result in suspension and termination. I'll share with you also a couple of other things. So when we're talking about penalties, the fines are going to be given if you acted without knowing that what you were doing was a violation. So you didn't know it was wrong. That's going to get you or your agency a fine. If you knew that you were doing something wrong and maybe tried to profit from it or do something like that, then you're going to get the jail terms too. But basically, I'm not doing that to scare you. It's real. I just am doing it to say that it does matter what you do, and you just got to take care to do your job within these parameters. Okay, using PHI, using protected health information. Because you all operate in a field setting, it applies differently to you all sometimes. Oftentimes, what you do in a situation is going to be evaluated on whether it was reasonable or not under the circumstances. You're going to ask yourself, is the action reasonable under the circumstances? Patient privacy, protected health information typically become issues in a pre-hospital setting. When you're loading the patient onto the rig, and so say it's a big accident scene, there's a lot going on, lots of different personnel there from different agencies. You got to pay attention to the information that you as a provider are giving out to other people. We're going to get into some examples and some specifics here. You have to focus on information requests going out. It doesn't really matter what the police officer is telling you or what this bystander is telling you. That's fine. You're just taking all that information so that you can do your job. What's important with HIPAA is what information you are communicating to other people. And here, who is making the request for information? We're going to go through some scenarios. So you'll have a good idea by the end of this, some of the things that you would see on scene. Other public safety agencies, generally speaking, are not guided by HIPAA. They don't have to follow it. 911 centers, fire departments, police, law enforcement agencies, they do not have to follow HIPAA. They're not in a healthcare providing setting, so they don't have to. They're not covered by HIPAA.
So that's why dispatch can give names over the radio.
Yeah.
Because they're not covered by HIPAA. They're not receiving payment from insurance companies for services, so therefore they're not covered by HIPAA. They can do that. We don't agree with that, and it's their practice not to do that. But sometimes that does occur, and everybody comes, or people come and say, "Hey, they're using names." Unfortunately, there's really nothing we can do about that.
She's going to probably answer this in a second, but the question that I have is, this is why I normally take my patients to the back of the truck to do an assessment on them, ask them questions, and I get kind of upset when those other entities get in the back of our truck while I'm trying to do my assessment, because then they're privy to those things that I'm asking.
She is going to cover that in this presentation, and that is acceptable because you provide care in the environment that you're in.
but ask if it, when it comes up later, ask them.
I normally tell them to get out. And I don't have a problem telling them that. They're my patient until I've said they're not, so.
What about fire departments that provide first response medical services?
If they're in the active role of patient care, then yes, they would, but they're not.
What if they don't bill?
Yeah, like a
Well,
volunteer.
then they're not gonna be, they're gonna have to take care, but HIPAA's not gonna apply to them.
Okay.
So, you know, they're gonna be respectful, hopefully, and
Like a non-transport first response.
yes. Okay, so we're talking about requests for protected health information. When somebody is asking you to provide some protected health information, you, and it's from one of these other public safety agencies like police or fire, you're gonna give that information, and if it's in the best interest of the patient for you to give that information. So the two things we've talked about so far, is it reasonable for me to give this information under the circumstances? Is it in the best interest of the patient? If you're saying yes to both of those things, you're probably okay. It's gonna require you to make a call based on your professional judgment. Protected health information is going to have to stay confidential for any other requests unless the patient gives you written authorization, which in your kind of work is often not plausible. And in other circumstances, it cannot be released unless you get that written consent.
I have a question about written authorization.
Yeah.
Is that a one-time thing or is that per occurrence?
Are you talking about like with it's a repeat patient?
Yeah, so it's a repeat patient, let's say that they've been here and they've signed that we can release, at the hospital, that we can release their information. Does that have to happen every time, or is that one time covers all?
I think it depends on how the release is written.
Okay.
But I would also say it doesn't hurt to ask every time.
Okay, just curious.
If you've got it written once, like if somebody if somebody later on requests, you all help someone on a run, they come, they're now a hospital patient, later on they decide to file a lawsuit against the hospital, they're gonna request a copy of their records, they're gonna request a copy of your run reports and anything else you all provided. In order for them to get a copy of those records, they have to sign a release that's saying that it's okay for you all to disclose their medical records.
In our situation, that is covered by the hospital, because the hospital is the maintainer of our medical records, so all of that information is coming from the hospital.
Right, so you don't even have to worry about
So
producing
if they sign at the
information.
hospital, we'll cover all the details.
Correct.
Okay, so another, some of you actually wrote in and you'll see some of your questions in here if you actually provided some. But this is another area that can be a little bit different. Friends and family of the patient you're treating. This is an exception to sharing protected health information. If you are talking about, if you're providing care to a patient and that patient's friend or family member needs some information in order for you to be able to provide care to that patient, like they have a medical condition, the patient's unable to tell you what their medical condition is, but a friend or family member is nearby and you're asking questions that's going to impact your care, you can ask questions of that family member and that family member can provide you with information, and that's not a HIPAA breach.
Because that's data coming in, not data going out.
Correct.
Okay.
Right.
But you can reciprocate that, so if you need to ask clarifying questions,
Right.
you would be able to ask those questions to that individual.
Yes. It's also, if you remember, the treatment, TPO, treatment, payment, or operations, that's in the treatment part too, so you're covered. The other part, sorry about this, is, oops, backwards. The payment arrangement. So if the patient is unconscious and can't agree to pay for the services, you all need some kind of signature, and there's a person who is an authorized person on behalf of that patient who can agree, you can talk with them about that as well. We're going to run through some scenarios, and this is going to hopefully solidify. EMS personnel can grant limited requests with the approval of the patient or by using your professional judgment when the patient is unable to respond on his or her own behalf. Okay, so here's your decision, 4-step decision method. Is the information coming in? That's okay. Is the information going out? If you're providing the information that's going out, think about what you're providing and to whom you're providing it. Who's making that request for protected health information and what is the reason? Is it reasonable? Is it in the best interest of the patient? Does it meet the treatment, payment, or operational requirements? Are you in the process of treating the patient? Are you talking with the other person about how the patient's going to pay for the services? Or are you in a training type environment? And if not, is the reason valid and appropriate under the circumstances? Does it meet with your professional judgment? And there's going to be gray areas here, so we'll talk about that. And I'll just say, if you remember nothing else, we're talking about protected health information. It's just confidential information. That's the key, confidential. And when something is confidential, you only want to share what is minimally necessary in order to do your job with somebody else. If you're the provider of the information, you want to share what's minimally necessary in order to get the task done. Electronic devices and HIPAA. Let's talk a little bit about this, because we are in the day and age of technology, and HIPAA has changed a lot since it was first came about in 1996. If you think about what life was like in 1996 versus what it is like now, it's pretty different in the electronic device department.
No kids, bro.
So some tips, if you are using an electronic device, like you're using a computer or your phone, lock the devices when they're not in use, report lost or stolen devices as soon as you recognize that they're lost or stolen, use unique passwords, change them periodically, don't share your passwords, do not disable security settings on any of these devices, and never leave an unsecured device or hard copy of a patient care report with protected health information on it unattended. So if you're in the middle of writing a report and you're not done, you get interrupted for some reason, you're going to have to take that patient care report with you or make sure that it is secure in some way so that you're not leaving PHI out there for somebody to stumble upon. I'll also add that on the electronic devices, Indiana statutes require that an EMS provider leave the pre-hospital assessment rule with the facility that you are delivering the patient to. You have to leave, that's why you all do it on carbon copy, right? So that you can leave that. If you also use that same pre-hospital assessment sheet, I keep wanting to call it something else, but I'm stumbling on a pre-hospital assessment sheet to get their signature for billing, right? You bring that back here and then you're able to put that information into your system for...
The back of the original has the signatures on it. We give them the second page for the hospital keeps the carbon copy.
Right.
We have the original signatures on the back of our page one.
But you bring that back here
Yeah.
and then process it through your systems here, so they can then get billed for your services.
Right.
Okay. But just know that part of the reason that you're doing the carbon copy is because state law requires you to do it that way. Okay, cell phones and HIPAA. The hospital policy forbids the taking or transmitting of any photographs that would contain protected health information, any kind of patient information. Then, because of that policy, this is what we were talking about, your forms are completed on carbon copies so that the hospital and other necessary personnel actually have copies of the documentation without you sending an electronic transmission. Text messages and photos taken on a cell phone can also be a HIPAA violation. There are ways that it can be done, but you've got to have secure messaging features, and we don't have that. So here are the risks associated.
Yeah, the only thing I'm gonna jump back, and we didn't
Yeah.
talk about this when you were preparing for this. We do have a program within the organization called Work Ready,
Oh, good,
As
okay.
Ready Act. It is HIPAA compliant.
Okay, great.
So in that system, there can be communication, but that's only in that system. It's not outside of that system. So
And does everybody have that?
everybody has the access to it, whether they decided to put it on their personal device or not, that was up to them.
Everybody has their own personal device when they're on scene. Okay. So unless you're using your personal device in that messaging system,
Correct.
you're not doing text messages or anything like that? Okay, got it.
I mean, you think about that just now.
Okay, so here's what the risks are with using cell phones, especially if they're your personal device. Texts are saved on phones. Texts are not subject to central monitoring. Carrier encryptions can be hacked, so AT&T might, we were all, I mean, if you had AT&T a couple months ago and you couldn't use your phone for like an hour. Decisions about patient care if they are done via text, they're not going to be documented in the patient's chart. And you want all decisions about a patient's care to be documented in the patient's chart. You can misdirect messages, you can miskey phone numbers, you can do all kinds of things. You also, some people have multiple users on a device. That would leave less cell phone, more like an iPad, if they were an iPad or something like that. There might be more than one user. And if that's the case, then you would potentially have an unauthorized user looking at protected health information. So that opens you up to risk.